Rad Squad, you may have seen the viral video of exotic dancer Genea Sky falling from a 15-foot pole on a main stage of Exotic Cabaret in Dallas. She fractured her jaw, sprained her ankle, and cracked some teeth in the fall. Today I'm here with Spar Bernstein's personal injury attorneys to discuss whether or not Genea Sky has a claim in personal injury court to pay for her medical expenses. While some people took to Twitter to laugh at Genea's fall on tape, she did have some serious injuries, which she announced on Instagram. She's needed serious medical attention, and Eric Langan, the CEO of RCI Hospitality Holdings, Inc., which owns the club, told TMZ that it was an accident that they are not liable for. So, team, Moshe, David, can you guys tell me, this begs the question, is she eligible for workers' comp or any sort of compensation from the club?
In order to answer that question, first let's discuss what workers' compensation is. Workers' compensation is a type of insurance provided by an employer to an employee in the event you are hurt on the job. For example, if God forbid we were to get injured here at Spar Bernstein, as long as it wasn't willful and intentional by the employer, then the insurance company provided by the Spar Bernstein firm would help me pay for my medical expenses and time out of work. That is workers' compensation. Now, what's the implication and consequence of that? If you're provided with workers' compensation insurance, you cannot sue your employer as a matter of law. That's the trade-off you have. If you get workers' comp, you can't sue your employer. Now, if your employer does not have workers' compensation because he refuses to pay for it, then you have a cause of action against your employer. Another way to sue your employer is if it's an intentional act. So if, God forbid, Brad Bernstein strikes me, God forbid, right? Then that's a cause of action against the actual employer.
Yeah.
And there's one more exception, which is very rare. It's the grave injury exception. If you suffer a grave injury at work, then you can sue your employer because the implications are far more worse in those circumstances.
And there's a policy behind not being able to sue your employer. As a society, we determine that we don't want to deter employers from having employees. It benefits our economy when employers hire people to work. So the legislature in New York and in other states decided that a trade-off, as opposed to having employees sue all their employers and potentially bankrupting them, the workers' compensation insurance scheme is an alternative to that.
And I think the one thing that we're failing to mention so far, in this case specifically, is was she an employee of the Exotic Club or not, right? And like barbers and dancers, folks that deal in mostly cash businesses like those, oftentimes are independent contractors.
Right.
And they are their own individual companies and they get paid 1099 income. And in those situations and circumstances, if you're an independent contractor, then workers' compensation wouldn't come into play.
Okay.
Right? So that's an important distinction that we'd have to make in this case. And the second thing is, looking at the pole itself, there's an area of the law, assumption of the risk, right? A thin 8-inch pole in circumference maybe, that's 15 feet in the air, inherently, if you look at it, if you're not a pro or trained to be on it, is inherently dangerous,
Yep.
right? And one of the expected things that can happen to you on a pole like that is what? That you fall.
Yep.
All right, so that's another really interesting legal thing to diagnose and really to figure out what the implications are and what she can recover in this case.
And just to piggyback off of that point, assumption of risk meaning there are certain inherently dangerous activities. So as an analogy, a baseball player, and he gets hit by a pitch that's thrown 100 miles an hour in the elbow or in the shoulder, and he breaks his elbow.
Yep.
The question is, can the baseball player sue the pitcher? And the answer would be no, because he consented to engaging in an inherently dangerous activity, which is playing sports, playing professional baseball. And you can apply this to any sport and any type of activity where there's an elevated risk of danger applicable, such as in this case, the dancer who unfortunately sustained very serious injuries because of a workplace accident.
Yeah, so you guys as professionals, should the strip club take responsibility for the accident, in your professional opinion?
So as a defense attorney, absolutely not. I would not offer to pay anything for this injury. Now again, we don't know exactly what the precise facts are, and when I say that I mean, was the pole defective? If the pole was defective in nature before she got onto the pole to start her dancing, then there's potential cause of action against the employer, the landlord, the owner, or the tenant of this exotic dance club, right? If it was wet, that's another thing you should look for. Because we don't have those facts in front of us, we don't know whether there was any effective nature of this pole to impute liability against the owner or the tenant.
The two most important words when we think about liability is but for. So if you're talking about the defective pole, but for the pole having a defect, she would have been able to successfully mount it, go up, go down. But for that defect, she wouldn't be hurt, right? So that's where the delineation is. And as a defense attorney, also, it's interesting you took that position. I can already imagine them looking at that video and say, she's not that hurt. She went right to dancing after, right? So in personal injury cases, the facts always come into play too, right? If you're so hurt, why are you continuing to dance? Now, from our perspective, we're obviously going to say shock of the moment, adrenaline, she didn't realize how hurt she was yet, and the medical records themselves don't lie. But as a defense attorney, that's what they're going to try to hang their hat on.
Yeah.
And keep in mind that insurance companies, they're not in the business of giving away cash. So anything they have against you, anything they can use, they will often use against you because they don't want to pay out. And that's why you need experienced personal injury attorneys who can investigate the facts, who can do the research, who know the law, who know how to deal with these insurance companies and ensure that they're not shortchanging anybody and they're paying out whenever they're legally responsible to pay out.
And lastly, one of the most important things to discuss in this particular set of facts, I don't know how it is in Texas, but here in New York, even if the pole was defective, it doesn't automatically impute liability against the owner of the club. Why? You have to prove notice. There are two types of notice. Actual notice, which means that the landlord or the owner knew about the defective pole, and if you didn't have actual notice, then it's something called constructive notice. Should he have known about the defect? Did it exist for 6 months prior to this accident? Those two questions are very important in analyzing whether you can impute liability against the landlord or owner.
And do you guys think that the strip club is responsible for removing the stripper poles?
Well, again,
after the case.
Again, if it's not defective in nature, then there's no reason to do anything, right? Why fix something that's not broken? And another thing, in New York, because we want to give reason for the landlord to repair things, subsequent remedial measures are not admissible in court. So for example, let's say you trip and fall on a defective sidewalk, and then the landlord repairs it the next day. You can't use that against the landlord because we want to create public policy that incentivizes landlords to fix things immediately to prevent further injury.
Okay, team, so the club is actually calling it an accident and there are no plans to remove the stripper poles as a result. Eric Langan, the CEO of RCI Hospitality Holdings, which owns the club, tells TMZ the club's position is the entertainer's choice, their own routine, and as a company, they exercise no control over a dancer's art form, so if they fall, it's on them.
What he's basically trying to say is that the exotic dancer caused her own accident.
And there's many different factors that the law provides in order to make the determination of whether or not someone is an independent contractor and then capable of suing, or an employee subject to the workers' compensation laws. For example, it's not sufficient just to have a contract to say, I am an independent contractor. The courts will look at how you were paid, W-2 versus 1099, what your hours were, who had control over your work. And a lot of these questions and factors would go into this case, would be applicable to this case in making the determination if she's entitled to workers' compensation or if she's an independent contractor who has the ability to sue an employer.
Yeah. And I mean, despite not being eligible for her compensation, one of her good friends even went as far as starting a GoFundMe for Genea to help cover her medical expenses, and it's already earned over $40,000.
Wow. Listen, we wish her the best. It's very disheartening to see something like that happen.
Gentlemen, thank you for sharing your professional opinions with me on this case. And Brad Squad, for any consultations for any personal injury, please contact us at 1-800-529-5465.
Prior successful results do not guarantee a similar outcome in the future. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.